Tasha, you can come up. Yes. Can I start? So good evening, everyone. Can we be quiet, please? We're about to start. Good evening again, everyone, and welcome to our 8th lecture for Criminal Law 1 for Semester 1. I would also like to give a special welcome to Dr. Janelle Matthews, who is the criminal law lecturer at UWKville, as well as the students in the first year criminal law class at UWKville. They will be joining us via UE live stream. Now today we have a very special guest lecturer, Mr. Jeremy Taylor, who is currently a senior Deputy Director of Public Prosecutions in the Office of the Director of Public Prosecutions, Jamaica. Now, Mr. Taylor has graciously agreed to present the lecture on accomplice liability, and he has titled the lecture, Monkey See, Monkey Do. Now, before we begin the lecture, I would like to give you a brief introduction as to who Mr. Jeremy Taylor is. And do we have any past Calabar High School students in the class? We have, oh, Vivian, okay. Well, Mr. Taylor is a past student of Calabar High School, or as it is sometimes called, Rabalak. Now, before entering the legal profession, Mr. Taylor trained as a teacher at the Michael Teachers College and also taught at his alma mater, Calabar High School. He completed his LLB degree at UWI-Caville and his legal education certificate at the Norman Manley Law School. Now, Mr. Taylor has had a long and prestigious career at the Office of the DPP, where he has been involved in numerous criminal law cases, including the infamous, yes, Vibes Cartel et al. Murder trial. Now, for those of you who are plugged into Jamaican current affairs, you might also have been exposed to Mr. Taylor's very strong views on issues related to court backlog, witness protection, and the justice system's response to sexual assaults. Now, I'm going to ask you now to join me in giving a warm UWI Mona Law welcome to Mr. Jeremy Taylor.
Ladies and gentlemen, thank you for the invitation. When Ms. Gray asked during Calabar Rabalak students, I heard somebody shout out, "Farties," and I cannot understand why the people from North Street like to make a big stink about fart is. But if it floats their boat, let them have it. But I do see a young man who was at Calabar when I was teaching, there for the 2 years that I was there. I also wish to thank you for coming out at 6 o'clock. It was at my request because at present I am prosecuting in the St. Catherine Circuit Court, and actually I have come straight from there here to give this lecture. So I would not have been available in the mornings. I would also like to, welcome Dr. Matthews and the students at Cave Hill. I still remember my 2 years that I did on the Cave Hill campus. Unlike many others, I quite enjoyed living in Barbados for those 2 years. And I hope many of those in that lecture will become future prosecutors, either in Barbados or in the rest of the Eastern Caribbean, where we'll be on the side of the angels, Jedi Knights, not Sith Lords. So we're going to welcome you to the exciting world of accessorial liability or secondary liability. So as future lawyers of the Caribbean, especially if you are going to practice in that branch of criminal litigation, you have to know something about parties to a crime. And you have to know how to assess liability. If you're a prosecutor, it helps you settle your indictments, helps you settle your charges. If you are a police officer, and every year I do this, I know there are a couple of police officers from the region or Jamaica who are usually here, it helps you know how to charge persons, either as a principal or either as an aider and abettor. And since we are in the age of gangs, and more gangs, not only in Jamaica but throughout the region, you should know that in Jamaica especially, 3 or more persons who participate in the commission of an offense can be charged with participating in a criminal organization. It doesn't matter that the organization was just formed on the spur of the moment to commit that one crime or commit that one offense. To Jamaican law, at that point, you are part of a gang or a criminal organization. And being a part of a criminal organization in those circumstances, you're all principals in the first degree. If you don't get anything out of this lecture, at least remember the title. When I did my first degree with Dr. Carolyn Cooper, she said if people don't remember your lecture, they must always remember at least the title of the lecture. So I hope you do, at the very least. So this is my introduction, and I will use images like this. I had a misspent youth. I enjoyed reading superhero comics and watching Animaniacs, which many of you were not born when was on TV, on JBC. You may see it on Hulu and YouTube or every now and then, but classic cartoons, especially Pinky and the Brain. Why define who is an accomplice? Why in criminal law do we need to do this? So you only get accomplice liability where two or more persons have been involved in the commission of an offense. One person can't be an accomplice. He may think he's more than one person, but one person cannot. It has to be two or more. And the reason for that is the procedure, that is the indictment and the charges and the evidence that will be led at trial, and it's also the punishment, the effect on sentence, and the possibility of being convicted for a lesser offense. For example, I use the example, manslaughter instead of murder. Now, who is an accomplice? Accomplice is a person who participates in a crime, or that nice legal Latin phrase, particeps criminis, in respect of the actual crime charged. And then, if you look at the definition, you will see what were the categories of accomplices. So you are either as a principal in the first degree, and we soon come to see who that is, a principal in the second degree, and we come to see who that is, accessories, that is, either an accessory before the fact, in the case of felonies, or an accessory after the fact, in case of felonies. In the case of misdemeanors, you would be a counselor, a procurer, or an aider and abettor. I have not made up these terms. If you look in the various statutes through your regions, you will see these terms being used. Jamaica tends to be an odd duck in relation to some of these, because I think in the Eastern Caribbean and other parts of the Caribbean, the distinction between felonies and misdemeanors has been abolished. But in Jamaica, it has been retained. So that's why we still have accessories before the fact and accessories after the fact. And I've listed some cases there if you want to look at the definition. So Davies and the DPP is a classic one for the classic definition for who is an accomplice. So you should read that one. 1954 appeal cases, page 378, and the particular definition can be found at page 400 of that case. There is a Jamaican case, the Queen and Beverly Champagny and others. Supreme Court Criminal Appeal, numbers 22 to 24 of 1980, decision handed down on September 30, 1983. And the particular definition can be found between pages 11 and 12, I think, of Mr. Justice Carr. And then there's this other English case, the Queen and Mendes and another, 2010, 3 All England reports at page 231. So that is who an accomplice is. Let me just repeat that again. Is either a principal in the first degree, is either a principal in the second degree, is either an accessory before the fact, is either an accessory after the fact, or he's a counselor, he's a procurer, or he's an aider and abettor. So a lot of these terms become important depending on the kind of case that you're dealing with. So let me just give by way of an illustration. In the case of the Queen against Adidja Palmer, Sean Campbell, Kahira Jones, and Andre St. John, which you perhaps know by a different name, the issue of accomplice liability was live. And in fact, in the appeal, the Privy Council / UK Supreme Court decision of Jogi was argued in relation to one of them. Why do I mention this? Because there is the issue, and I'm not going to say too much because we're still awaiting on an appellate decision, but I can say this because it was part of the evidence. There is the issue as to the liability of Mr. Sean Campbell. Well, he really wasn't that stormy. The issue was liability of Mr. Sean Campbell. So we have text messages between him and his baby mother, in which he says, somebody got dead tonight. Typical man does not listen to baby mother who tells him, you don't get mixed up in that. And you know, he has this back and forth with the baby mother. So these text messages are being sent while Lizard is in the back of the car, sending text messages to his girlfriend, asking her to call the police. I am at such and such a location. Baby, I got dead tonight. Do something, teacher, go kill me tonight. So anyway, and we track that journey through the cell phone evidence. So they reach Meadowbrook, and they let off Lizard, they let off our witness, and so on. And then we notice that after a couple minutes, we see Mr. Campbell's phone starting the journey back from Meadowbrook to Waterford, you know, the seat of Gaza, the empire, you know. And so there is the question as to how deep was Mr. Campbell's involvement with the murder. You know, what should he have been classified as? Well, the prosecution, if we had wanted, we could have tried him as an accessory before the fact. We could have done so. And I'm only mentioning this in passing because the way to look at one accessory before the fact is in greater detail. But we decided to charge him as a principal for the murder. What allowed me to do that? Section 81 of the Offenses Against the Persons Act, which states that any accessory before the fact or after the fact can be tried as a principal. So we tried him as a principal, and he got a principal sentence. Not as much as a big man, but he still got a principal sentence, so we didn't disrespect him. Now, what do we say about secondary liability of a crime? And I've cited this Australian case. At its most basic level, secondary liability is found on a principle of causation, that a defendant is liable for an offense committed by a principal actor if by his conduct he has caused or materially contributed to the commission of the offense. Just pause. Come back to Mr. Campbell again. How did Mr. Campbell contribute materially to the commission of the offense? Mr. Campbell delivered the deceased knowing what was going to happen to him. So it's not like he was an innocent agent, which we're going to come back and look at. He carried him to the house knowing that he was going to be murdered. With the requisite mental element, so I assume that you all know actus reus and mens rea already. That must have been your first lecture. But let me just make sure. Sir, with the New York skyline. Yes, you. What is mens rea? It's the guilty mind. So danger.
No.
Really? All right. Yes, it is the guilty mind. It is the intent. This is the mental state you have. You know that you are committing the crime deliberately. You're doing it on purpose. It's not coincidence. It is not happenstance. It is not accident. You set out to do it. So, let us come back to Mr. Campbell. The crime of murder has a specific mens rea. In fact, the threshold for murder is very low. Because at the very least, you must have intended to do grievous bodily harm to the person. So the threshold for murder is very, so initially you may not have intended to kill. But you decide, say, I'm going to put on some licks upon this person. Him will remember this day. Him can't walk after this. Well, if him dead out it, it's murder. Because you intend to cause grievous bodily harm, which leads to death, you have had the requisite mens rea. So you have to have that. And actus reus, is the actual killing. And Callanan, Mr. Justice Callanan of the High Court of Australia, if you look at it, says that at common law, crimes were originally divided into 3 categories. Treasons, which we still have, are now governed by statute. I think nearly every region in the territory has a treason felony act or a treason act. Felonies, which are grave crimes. So in Jamaica, the major felonies are like murder and gun crimes, such as illegal possession of firearm and shooting with intent. And misdemeanors. In the bad old days when I used to prosecute, or the good old days, depending on how you look at it, a misdemeanor would be like possession of ganja, dealing in ganja, what you may consider minor offenses. But like I say, Jamaica still retains that categorization of offenses. In the rest of the Caribbean, those categories have been abolished. There is no distinction between felonies and misdemeanors. And if you look at the Queen and Stringer and another, they speak about 3 categories of persons in relation to felonies: principal in the first degree, principals in the second degree, and accessories before and after the fact. Now, as I've said more than once, the distinction between felonies and misdemeanors has been abolished in other parts of the Caribbean. In Bank of Jamaica, against Dextra Bank, 31 JLR 361, Mr. Justice Carey held that in Jamaica, the distinction has only historical interest and no practical significance. Let me say, and any opinion I express here is the opinion of Jeremy Taylor alone. It's not the opinion of the DPP, and certainly it's not the opinion of Ms. Paula Llewellyn. Let me state that Mr. Justice Carey's statement here is obiter. And let me hope that you know what I mean when I say it is obiter. This is obiter dicta, and it is incorrect obiter dicta because it still has practical significance. It still has an effect on what kind of offenses that we as prosecutors can indict for and what the police can charge for. So what then is the difference between felonies and misdemeanors? The first is that the law is different with relation to parties for a crime. So in felonies, you have principals. Principals in the first degree, principals in the second degree, and you have accessories before and after the fact. So in Jamaica, where this distinction is still live, you can only charge an accessory before the fact for a felony. Can't charge it for a misdemeanor. You can only charge an accessory after the fact for a felony. You can't charge it for a misdemeanor. So let me give another illustration. For those of you who have been following the news, there is one Tesha Miller who is to go on trial soon. And for those of you who are from Spanish Town, that name may sound very, very familiar to you. Mr. Miller has been indicted on the 2 accessory counts: accessory before the fact and accessory after the fact for the murder of Mr. Douglas Chambers, who was the JUTC chairman at the time. And we can only do that because murder in Jamaica is still a felony. So we have evidence, and we hope it stands up, that he knew before the murder was committed, and he gave encouragement to it. Those are the allegations. And because I'm being recorded, let me make sure I say it. Those are the allegations, not yet proven. And on the evidence that we have before us, we also have that the person who allegedly committed the murder of Mr. Douglas Chambers, he assisted him in leaving the country. So that is why we have charged him for being an accessory before or after the fact. We don't have any evidence that he was directly involved in the murder itself. So that is an example of the practical outworkings of how you would charge people for offenses that are felonies. Yes?
So I have a... Caville.
Yes.
The question is, in those jurisdictions where the distinction between felonies and misdemeanor no longer exists, how do those jurisdictions deal with accessory before the fact and accessory after the fact?
So now I come now to the second part of this whole thing. Thank you, Kayfield. Now, with misdemeanors, there are no accessories. How then do you deal with that? Well, the persons would either be charged as an aider and abettor, either as a counselor, or either as a procurer. So because it's not a felony, you won't have accessories. So for misdemeanor offenses, let me make it clear. There are no accessories in misdemeanor offenses. But you have aiders and abettors, you have counselors, and you have procurers. So let us say murder was a misdemeanor. In that case then, to answer Caville's question, the person who I just spoke about would either have been charged as a counselor, as having counseled the murder, or as having procured it. But he wouldn't be charged as a principal for it. So that is how the jurisdictions which have abolished the distinction between felonies and misdemeanors would deal with it. So I hope they have heard. Again, and if we look at this case, which makes a point, that's a Minister of Food against O'Rourke, 1951, Northern Ireland cases, or Northern Ireland reports at page 97, where the court held, in point of law, there are no accessories in misdemeanors. And those who aid and abet the commission of offenses in this category may be proceeded against and dealt with as principals. So you have a case law which speaks about the fact that there are no accessories in misdemeanors. Now, so that was the first. The second one, why we say, and this again applies to those jurisdictions where felonies and misdemeanors are still active, there are certain offenses which cannot be charged unless the offense is a felony. So for example, the common law offenses of misprision of felony and compounding of felony. Now, what is misprision of felony? This is a common law offense that both we and the police have revived in recent times. So you are aware of a felony having been committed. Say you are at home, your boyfriend comes home, because usually women will say come for this, but there have been men. Come home and say, well, you know, I've committed this murder. Here are my bloody clothes. And you go and you take up your bleach and you wash and you scrub to your heart's content because, you know, the amount of blood shows that he's done a good amount of work that day. Anyway, somebody tips off the police and you are arrested. And perhaps you say, even though the police officer has cautioned you, you decide to say, but me no do nothing. Yeah, him come and tell me. True, me wash him clothes and so. Well, police officer says, yes, you knew about it? And she says, yes, and you did not report it? No, I never reported it. Well, me I'm not informer for dead. Misprision of felony. The fact is that you knew about this felony and you would never pass on that information to law enforcement. I think that the sentence that you can only get for it is ridiculous, but right now it offers us a bargaining chip in plea bargains, so we haven't asked for it to be increased yet, so common law misdemeanor, 2 years. Thirdly, and why is it important in relation to the distinction between felonies and misdemeanors? And why is it that I say that Mr. Justice Carey, made an incorrect obiter dictum? It affects the powers of arrest by the police. At common law, the police have the power to arrest without a warrant on reasonable suspicion of a felony having been committed. So this is why the police can swear out a warrant for murder just on the reasonable suspicion, somebody giving them enough information, they can go and swear out a warrant for your arrest. Whereas, for misdemeanors, unless it has been committed in the presence of the police, they need to take out a warrant to arrest you. So the police can only arrest without a warrant if the misdemeanor has been committed in their presence. So like for those of you who like to go on what is called Jamaica Carnival and you have your rum-soaked soca jump-ups, and every now and then somebody gets drunk and takes out a gun and begins to stagger and point it at people, and so on. That was a case in which the police could arrest because that was a misdemeanor committed in the face of the police. Police officer saw it, police officer arrested it. But the good people of Jamaica thought his only video evidence should be allowed to convict him. So the people were pointing at and were ducking at the moving of the gun. Never came to court, and so we had to start to send home the man. But at least his firearms license was lost. So that is another reason, at least in those jurisdictions, why the importance between felonies and misdemeanors is important. Fourthly, sorry, I have a question. Yes, at the back. No, reviving.
Sorry. Can you explain a little more? Does it only deal with those who are, for example, intimately related to the person who committed the crime?
No, you don't have to be related to the person. But the offense has to be a felony.
Oh.
So it's not every offense it can be used for. It has to be an offense which the statute says is a felony.
So does that then create a duty to report?
Yes. Basically, that is what the law is telling you. You know about crime, you really ought to report it. So, let me hope that you are not asking for a way, for a loophole to get out of something. So, fourthly, it affects trial procedure. For a felony, the accused person has to be present throughout the trial proceedings. Now, you can only proceed without the accused person's absence if the person absents himself voluntarily in the trial. So let us say, let me give an example. So 2 years ago, I prosecuted a fellow named Theo Hamilton, and I indicted him for murder and conspiracy to prevent the lawful burial of a corpse. You know, this thing about where people kill you and then bury you in a shallow grave is also a criminal offense, because the law says that every person is entitled to a Christian burial. So, we charged him for the two. In fact, he had been charged with 3 others. Now, Mr. Hamilton was the only one who gave a confession. And all Mr. Hamilton said, was, look, I wasn't, I know that they killed him, but I only helped with the burial. So, and we knew this because we knew that the 3 people from way out East Kingston were 3 wretched people and really wanted them behind bars. I presented a plea agreement to Mr. Hamilton. Mr. Hamilton, will you plead guilty to conspiracy to prevent the lawful burial of a corpse and give the evidence that you have in your caution statement against the other 3? Mr. Hamilton said, no, I will not do any such thing. So what happens at the beginning of the trial? Because at the beginning of the trial, the only evidence I have against the other 3 is in Mr. Hamilton's caution statement. And what one accused says there is not evidence against the others. I said, Judge, let go the other 3. We're proceeding against Mr. Hamilton alone. So Mr. Hamilton is there, and it's the first time I've ever seen one of them, with a shocked look as he sees the other 3, walk out of the dock and gone home. And he has to stay behind to do his trial. Well, anyway, we break for lunch. And when we resume at 2 o'clock, Mr. Hamilton don't come back. So the lawyer is trying to call Mr. Hamilton. Mr. Hamilton, where are you? Voicemail. But because the trial had started already and evidence had been taken, the trial was able to continue in his absence. and to show Mr. Hamilton fool, because the jury acquitted him of the murder, but convicted him for the burial. But he wasn't there. Anyway, this case wrapped up on the Thursday. The Sunday, when I'm listening to RJR 7 o'clock news, the body of one Theo Hamilton was found in a shallow grave. So that was the outcome. Had he stayed, his 2 years would have finished by now, and he would have been alive. No doubt the three who were let go decided that he was the informer and decided to deal with him. But anyway, he was not alive to come back for a sentence. Where the offense is a misdemeanor, the accused's presence is not indispensably necessary. So the ideal thing is for you to be present at trial. So you see this happen mostly in traffic cases, where people send somebody to court to go and plead out the case for them. I personally believe it's not correct procedure. I believe you can only really take the plea from the accused person. But I do recall at a time when I was a clerk of court in St. Catherine, where it was a judge who had been charged with a speeding ticket. And he did not come in person. He sent his close protection officer to go and enter the plea on the ticket for him. So it's not indispensably necessary. So you can actually do certain procedures with certain kind of misdemeanors, but the lesser, the better. So like traffic offenses, this happens a lot, and I suspect not only in Jamaica. So then, let us come to look at the categories of accomplices. And let us begin with felonies. These are the categories for felonies. A principal in the first degree, as I have been saying before, a principal in the second degree, and accessory before the fact, or an accessory after the fact. I'm going to read this part. In these categories, liability is determined as whether or not it is primary, that is a person committing the actus reus, or whether it is derivative, that is, you are not present at the commission of the actus reus, but you still managed to render some kind of assistance. So let us begin with principals in the first degree. At common law, principal in the first degree is the person who commits the actus reus. So in murder, it is the person who has done the actual killing. Likewise, for manslaughter, it is the person who has done the actual killing. For illegal possession of firearm, it is the person who is found with the gun in his or her possession. In shooting with intent, it is the person who fired the gun. In poisonings, it is the person who dispensed the poison. In cases of larceny or in other Caribbean jurisdictions, theft, it is the old thief. It is the person who has stolen the item. So these are who are principals in the first degree. So the principal in the first degree is very easy. His liability is easy to determine. You can have joint principals, meaning that it is possible for more than one person to be principals in the first degree. I use the example here where two defendants stabbed the victim to death. Well, I think I mentioned it here, and I will come to it, but there's the Trinidadian case of Mohan and the Queen, which we will come to look at. If I don't see it here, remind me to tell you about it. So in the case of Errington and others, the deceased was drunk and was sleeping off his rum or his drink. The prisoners, or the accused persons, more than one, came around him, piled up straw around him, and then threw hot coal upon his belly, the consequence of which The straw became alit, and he was burnt to death. So all those persons were convicted as principals in the first degree for manslaughter. And manslaughter because they may have done it for fun, but they probably didn't think that he was going to die or didn't intend him to be killed. So in criminal law, when you come to look at recklessness, this is something that you will look at. There are borderline cases where it will not be clear. Let me see if I put the facts in this one. Yes. So let me come back to the case of the Queen and Salmon, Hancock and Salmon. 1886 Queen's Bench Division at page 79. Let me repeat that again for the purpose of Cave Hill. There are cases where to be borderline, that you can't determine who is the actual principal. So everybody's a joint principal. And that is the case of the Queen and Salmon, Hancock and Salmon, 1880, 6 Queen's Bench Division at page 79. What are the facts in this case? So this is a case in which all 3 persons seem to have been part of some voluntary militia. And they had done training with a firearm. Now, they were supposed to return the gun, but they never returned it. They decided to take it, and 3 grown men decided to go and play with the gun. So they all went off, and each man bust a shot off of the gun. Well, some 393 yards away, there was a boy in a tree. Now, in 1880, in England, I can't believe the boy would be in a tree just climbing it for fun. I suspect in Jamaica for today, he would have been a pre-deal larcenist in training. But anyway, there was a boy in a tree. He was shot, fell out of the tree, and died. The issue is, which one fired the fatal shot? Was it George Salmon, was it Hancock, or was it J. Salmon? So let me throw it out to that corner way at the end of the lecture theater. Madam, in the first row with the laptop. Are you hearing me? Who is guilty? Not hearing me. As a future lawyer, you have to project your voice. The Jamaican courts do have mics. I'm saying all of them. Let me hear your submissions, counsel. Why all of them? Why all of them?
You guys hear me? I would say all of them because they were all firing shots, so they're probably the accessories to the crime.
I was with you until you said accessories. Sir, right here. You, yes, you that I'm pointing on. You. No, don't behind you. Who is guilty?
Good evening, everybody. Okay, so I would say all 3 would be guilty, particularly because it would be very difficult of the court to determine which one specifically fired the shot. But I don't know I might need some help in terms of exactly what the charge would actually be. Who would actually be charged, sorry? Or
why you need help with that? You said that all are guilty. Why you need help with who would be charged? All right. I will let you think about that part. Way at the back. You, sir, in the brown shirt. Yes, you, looking at yourself. Can we all listen, please? Can we all listen, please?
Sir, How did you see me? Anyway,
It's that old Ramalak vision.
but I was assuming because we don't know which one of the shots, because all three of them use the same weapon, right? Shooting at the same time. With 3 shots, and we don't know which one hit the boy, right? So I'm thinking all 3 will be charged for recklessness because all 3 of them was behaving in a reckless behavior that caused the death of the boy. So,
But recklessness is not an offense. No, you know. Let me just take one more. Miss who is rocking the bipartisan colors there with the green and the corporate orange.
She's actually from St. Lucia.
Oh. Well, you've acclimatized yourself well to the political culture.
All of them, because all of them were firing shots, and all of them failed in their public duty to fire the shots in a safe place, so it created a dangerous situation. So all of them will be principal offenders, because none of them took the necessary precautions.
Okay. And this was just a test because the answer is actually right there on the slide. Yes. A response from KD, let me hear. Proves my point about open book tests. Yes.
So someone at Cable says all of them will be guilty because all of them were armed, taking turns in firing the shots.
So like somebody was reading the slide. Yes, all of them would be guilty. So all of them are principals in the first degree. All of them are joint principals. They had the gun, they fired it, and they all fired in the direction where the boy was. So it would be silly for the law to go and try to determine who actually fired the fatal shot. So all 3 of them were charged for manslaughter. So let me also come to the case of Mohan and the Queen. Mohan and the Queen is from Trinidad and Tobago. Any Trinbagonians here? None?
Yes, one at the front. Shadian.
Boy, sir, you shame on your country, sir? Anyway, yes, so this is actually from your home country. So what happens? And it's a typical Caribbean case, you know, how mighty contests can arise from trivial things and how people can lose their life over foolishness. So what happens? So a typical Caribbean scene is a big yard, although I don't think you call them that in Trinidad. But it's a big yard. And somebody has taken set on this youngster who has a disability. In fact, the accused person, Mohan, one of the Mohans, took a set on this young man who had a disability. So the deceased intervenes on behalf of the young man. Well, Mr. Mohan just did not like that. Thought it was disrespectful. So Mr. Mohan picks up his machete and begins chasing the deceased around the big yard. Unknown to the deceased, who when he was running around that tree, Mohan's father was around that tree. He also had a machete. And so he jumps out, aha! And the 2 of them begin one big chop fest of this young man. So, the sensible jurors of Trinidad and Tobago convicted them for murder. Goes to the Court of Appeal. Court of Appeal upholds the conviction. So, you know there's a sentiment in the Caribbean that local courts can't give you justice. So you must go to England. You must go to Privy Council. And what do they go to the Privy Council on? They go to the Privy Council on that clearly none of them should be convicted because nobody was able to identify who inflicted the fatal chop. Which chop took the life of the deceased? Serious, serious argument. Well, the Privy Council ran them. Privy Council held that they were all joint principals, and also that each one was aiding and abetting the other. So their convictions were affirmed. But like I said, that typical Caribbean case which arises out of foolishness. I have never seen a region where people are so hot-headed and willing to kill and die for nonsense. So let us come to the whole concept of the innocent agent. An innocent agent, a nice defense. So innocent agent may be a principal in the first degree because he may have committed the actus reus, but he does not have the necessary mens rea. Where does this usually arise? You normally see it in cases where people use children to commit crimes and commit it in a way that the child does not know that he's committing a crime. So that part is important. So let us look at some aspects of children and the criminal liability of children. In Jamaica, criminal liability begins at age 12. I don't know where it begins in the rest of the Caribbean, but I know in Jamaica it begins at age 12. So below age 12, the law presumes they don't have the capacity to commit a crime. They are, nice Latin phrase again, dole incapax. Now, some of you may have remembered, maybe about 2 or 3 years ago, a case out of Trelawney where an 11-year-old committed murder, killed somebody. And the outrage was, by the good people of Trelawney, and even more so by the relatives of the deceased, was that the police could not charge a child for murder. What happened? They had to put him before the family court. As I don't remember they put him before family court as an uncontrollable child or as a child in need of care and protection. And why was that? It's really not innocent agent. It's really more for dole incapax. But why was that? Because the law said he had not yet reached the age of criminal responsibility. So if he had waited until he was 12, we could have scraped him up and charged him for murder. But he did it when he was 11. So, but many of these cases are done where the person does not have the mens rea. So let me just read this part of it. The doctrine of innocent agency or instrumentality necessarily depends for its operation upon the innocence of the instrument used by the perpetrator to commit the offense. If the instrument is not innocent, but at the time of the commission of the offense has a consciousness of guilt, the instrument may be accountable. So if the agent has the mens rea, he can't use this as a defense. So he can't have the mens rea. And then you can look at the case of the Queen and Bull and Schmidt, 1845, one Cox criminal case at page 281. Now, let me say this frankly. If you are looking for cases, you're not going to find much reported cases on this area of the law. And you're only going to find very, very old English cases. You're not going to find one Caribbean decision on it in any of the courts in the region. And I think the only place where I have seen modern decisions dealing with this arise out of Australia and New Zealand, where it seems to be a defense that the lawyers are using out there. Still on felonies, we come now to look at principals in the second degree, and especially accessorial liability. Who is a principal in the second degree? A principal in the second degree is a person who is present at the commission of the offense and aids and abets in its commission. So, if you're dealing with a principal in the second degree, you're talking about more than one perpetrator. So, you know, and I can't speak for any other Caribbean territory, but you know that Jamaican wrongdoers like to run in packs. They are like wolf packs. And so you usually have a leader who instigates and does everything, and you have some footmen who join in and do it. So if people going to drop licks, somebody have to come in and get them one thump, one kick, and so on this thing. So those persons would be principal in the second degree. However, a principal in the second degree is equally liable in terms of punishment as a principal in the first degree, because he's there actively aiding and abetting the commission of the offense. So let me use an example of a principal in the second degree. Now, in relation to gun crimes in Jamaica, can't speak about Firearms Act in any other region. But the Firearms Act of Jamaica has a deeming provision that if you are with a person who is with a firearm, and that person commits either an assault or a felony, and you are in the company of this person, you are deemed also to be in illegal possession of the firearm. And you would be surprised at the amount of people before the gun court who are not the persons holding the gun. They were the aiders and abettors. So the man come with the gun and hold you up. Man number two come and dig up in your pocket and take out your wallet, take out your iPhone, take off your chain, and all of these things. Very often in the gun court, this is the person who is held. Man with the gun still at large if the police have not killed him yet. So, and that person can get the same punishment as if he was the one with the gun. So that is a classic illustration of a principle in the first degree within the Jamaican context, especially in relation to firearms offenses. So, if any of you know people who have guns, and you know that when you go out with them, that them have gun, and you know that your friend is a particular hothead, and you see him drinking plenty, or even not, and getting wild, I would say this is the time and you do as Mr. Vegas, take away yourself. Do not say do or die are going down with my brethren. Because I guarantee you, you perhaps will be the one held, and your brethren gone about in business. So then, also in relation to a principle in the second degree, presence is important. Now, let me make this point clear. Mere presence at a crime is not enough to say that you are an aider or abettor or a principal in the first degree. There has to be that something more. So you have to show that you actually gave encouragement or you participated. So if that was the case, nearly everybody in Jamaica who stand up and film things on their phone, especially criminal incidents, could be charged as a principal in the second degree, just on the occasion of just mere presence alone. So it's not mere presence alone. You have to have that something more. And that something more is both the mens rea and the actus reus. Let me highlight to the last paragraph there. There is no duty generally in law to intervene and stop a crime that is taking place. So, or even to help rescue somebody. So like say, if you went to the university pool and you saw somebody drowning, and instead of responding, you took out your phone and you decided to film it. And the person drowned before you. And you share this on WhatsApp and Snapchat or Instagram or whatever all the social media things you young people are into. Nowadays, I can't charge him for anything. Can't indict him for anything. He has no duty to intervene. But let us say it was my brother. Or let us say it was my father. Or let us say it was a police officer or a fireman who was there. Then that person standing up and filming will find themselves in deep doo-doo. Because they had a duty to help, to intervene, and to save. So, if you look at this case, the Queen and Bland, for the aider and abettor to be liable, he must be present in pursuance of an agreement that the crime is committed or give assistance and encouragement in fact. What we mean being present in pursuance? So this person could be the lookout. This is the person who is keeping up to see if the owner of the place come back or if a radar car is driving up the road. And then they warn you. So that was actually the case in Denny Chaplin. And Denny Chaplin is really a common design case, but Denny Chaplin is a murder committed in the course and furtherance of a burglary. And Denny Chaplin's defense was, I was only the lookout. I was only the lookout. It didn't save him from being convicted for murder. And he was convicted at a time when we were still hanging people. So, let me just speak to this aspect of it. And this part is perhaps just unique to Jamaicans, since I'm not aware of the firearms legislation in other territories. But in relation to guns in Jamaica, you must be in the company of the principal offender. The principal offender must have used the gun to commit an offense. And the circumstances must give rise to the reasonable presumption that he was present to aid and abet. And 4, which is important, the absence of reasonable excuse, meaning you need to have an excuse as to why you were present, which is reasonable and does not fall into category 1, 2, or 3. So you go with a person, as I said again, and that one person has a gun, and you all go, and this person with the gun commits the offense, and you are there either giving support in terms of numbers, but sometimes you don't have to do anything. You're present. There's a crowd is there to be intimidatory enough. So this is what is the law in relation to guns in Jamaica. So now, let me move to misdemeanors. I am moving now to misdemeanors in relation to a principal in the second degree. What does the term aiding and abetting mean? Now, if you look at the case law, you're not going to find very helpful definitions. In fact, the judges are bad at defining what this term means. So I have found that Halsbury's Law of England gives a very good definition of aiding and abetting. So aid is used to describe the activity of a person who helps, supports, or assists. And abet is used to describe the activity of a person who incites, instigates, or encourages. And because very often both the aiding and abetting run together, you normally see offenses charged, whether in Jamaica or other parts of the Caribbean, for aiding and abetting. So I have found it's a very good definition for aiding and abetting, and I commend it to you. So let us look at the others. What does counsel mean? And again, I have decided to use Halsbury's Laws of England because the case law, I find, does not give very good definitions. And you are at the stage where you're all doing law, here at Cavill and so on. This is a point at which you must critique these cases. You don't need to genuflect before them. These judges get it wrong plenty times. Or you can see where the law is outmoded or the law is taken a wrong term. I am sure Ms. Gray would want some nice critical discourse on some of the cases that when she gives you the assignments or the exams. So counsel means advise, encourage, or the like. And procure means by setting out to see that it is committed. I have put the last part here. Procure means to produce by endeavor, because one of the cases actually defines procure in that way. Procure means to produce by endeavor. And I know that when I read it, I said, but my God, what in heaven's name does this judge mean? To produce by endeavor. With the ordinary law student or even the ordinary lawyer, because the truth is, many lawyers still don't understand law, even though they've been practicing it for years. Some of them not even good at the practice. what does produced by endeavor mean? So I have found that Halsbury's gives a very good definition. So now, it is quite possible for a principal in the first degree to be acquitted and the secondary party convicted. That is quite possible. And I'll give an illustration. Years ago, when I was clerk of court in St. Catherine, and I see somebody here who knows me from when I was clerk of court in St. Catherine, I did a fraud that came out of Caymanas Park. And it was one of the managers who was running the fraud and had one of the cashiers assisting him. Well, I spoke to the lawyer for the cashier and said, look, man, your client give a caution statement. You know that she's going down. Why she don't run a thing with me? Testify against the man. And the real big brain will go say, no, man, you have no case against my client. You have no case against my client. My client will be acquitted. Well, so said, so done. The manager walked, and she was convicted. And she was a secondary party in this thing. So it is possible for the principal in the first degree to be acquitted. So I want to commend this case to you. It's a case out of St. Vincent and the Grenadines. It is Anjay Charles against the Queen. And it is on the Eastern Caribbean Court of Appeal website, if you go there and type it in. But in Anjay Charles and the Queen, Anjay had been convicted of 9 counts, including 3 murders. His co-accused had all been let go by the jury. He was the one man who was convicted. What was Anjay's defense before the Court of Appeal? Anjay's defense was, if the principals have been acquitted, how can I, as a secondary person, be convicted? That was his submission before the Court of Appeal, and this was the response by Mr. Justice Webster of the Eastern Caribbean Court of Appeal. A secondary party may be tried and convicted whether or not the principal has been tried. Indeed, the fact that the alleged principal has been acquitted, whether on a procedural point or on the merits, is no bar to the conviction of a secondary party. You know, let me give the citation for this because I don't know if the people at Cave Hill are able to see the PowerPoint. So it's Anjay Charles against the Queen, HCRAP 2013/0016, decision handed down April 6, 2017. So I commend this case to as a Caribbean case which deals with exposition on this principle, that the secondary party can be convicted and the principal be acquitted. Moving, because I'm trying to get to common design quickly. There can be participation by inactivity, where the defendant has a right or duty to control the actions of another, and he deliberately refrains from exercising. So Tuck and Robson is actually a case in England at the time when pubs, what we know as bars, had a set closing time. Everybody knows that in Jamaica and the Caribbean, no bar has a set closing time. But in England, they had to close by a certain hour. And although they used to have it this way, the person would call time, and that's the point where all the customers should get up and start leaving and so on. Well, he called time and nobody started moving. And it looked like he started to sell them even more drinks after that. So undercover police came in, saw this, arrested and charged him for it. And this was a principle that came out of it. He had a duty to see that it happened. He didn't do anything. He was liable. The mens rea of secondary parties. The secondary party must have the mens rea of the principal party. So there must be a meeting of the minds. But you will see that this is not easy to categorize when we come to look at cases of common design. and you look at the scope of the common design. Because in common design cases, the defense usually arises, I agreed to commit a crime of a particular nature. Good heavens, I had no idea he was going to take the gun and shoot and kill somebody when we were committing this crime. I was shocked and appalled, and that kind of way. So, but generally, the secondary party must have the same mens rea as the principal in the first degree. But when we come to look at common design, we will see that that is not actually the case at all times. So the defendant must do acts intending to assist or encourage the principal. The intention is not to be equated with foresight. And let me come again. This is actually taken from Jogi and Radek, case you must read on common design. And then a person cannot be convicted as a secondary party unless he was aware of all the facts essential to make the act done a crime. So let me move on. An accessory before the fact. Who is an accessory before the fact? An accessory before the fact is one who, although he's absent, and that part about absence is important, because if he's present, then he moves from being an accessory to a principal in the second degree. So the thing with accessories is that they are never present when the crime is committed. Or rather, when the felony is committed. So their role usually is in procuring or counseling or abetting another person to commit a felony. So these are some of the principles. So number one is the one I just said. He's an aider and abetter and not an accessory before the fact. The King and Croft is an interesting case. It was a suicide pact case. And, you know, two young lovers thinking that, oh, we can't live without each other. Oh, cruel world, let us die together, and so on. But, you know, in cases of romance and the heart, women are stronger than men. So the woman goes ahead and kills herself. Man catch him afraid. I run off. So this was a case as to whether or not. I think he was outside when he heard the shot. And he just ran. So women, this thing about I would die for you. Don't do it. Many of them don't deserve it. So here's the thing was whether or not, you know, he was a principal in the second degree, or as whether or not he was an aid and abetter or an accessory before the fact. I want to come to the case of Saunders at number 5. Now, Saunders is a very old case. 1573, it's a 16th century case. Volume 75, English Reports, page 706. Because where the defendant advises one crime and the principal in the first degree commits another, the defendant will not be liable as a principal in the first. So let me come now to the facts of the Queen against Saunders, a case decided when Elizabeth I was Queen of England. So, ladies and gentlemen, this is the days before divorce. It's the days where you couldn't get rid of your partner if you wanted to. You know, you had to go through church courts, and you have to get annulments, and you have to go and try prove all kind of things which never happened. And his case was difficult because he at least had a child with this woman, so you can't say there was no consortium or no sex. The marriage was never consummated. So he wants to get rid of his wife because although he's not a Caribbean man, he has found a deputy. So what does he do? He goes to Saunders. I want to get rid of my wife. You have any advice for me? Now, Saunders thought he was being a good friend. Saunders says, here, take this apple, poison it, and give it to your wife. So, the defendant, who does not seem to have been a particularly bright person, decides to run with the plan. So he takes the apple, or he takes an apple, and he poisons it. And the wife perhaps should have been suspicious, because here's a husband coming all loving. Oh, wife, how are you? Have a seat. Here, have this apple. I went out and I brought it for you. She should have been suspicious. If your husband hasn't been romantic for some time, all of a sudden then he starts. So anyway, she was probably glad for a little romance from her husband. So she says, all right, who comes in? But the little infant daughter. And the wife says, look, your father just gave me this apple. Come, have a piece. So what does Saunders do? Now, from the text of the case, it says that Saunders loved his little daughter very much, but he couldn't disclose the plan. So instead of come and see if him accidentally box out the apple out of her hand and then say, oops, 5-second rule, can't eat it. No, he stands there and watches wife and daughter eat the apple. Daughter dies. So, I don't remember if the wife died, but I know the daughter died. Saunders is arrested as a principal in the second degree for the death of the daughter. Saunders gets away. How does Saunders get away? How did Saunders get away? The court held Saunders counseled the murder of the wife, not the daughter. So the fact that the daughter died he's not liable for that. So Saunders got away. Mr. Archer, who was the husband, later went to meet the executioner for the death of it. So that's a very interesting case. And again, it shows the whole principles of being an accessory before the fact. So Saunders was an accessory before the fact for the attempted murder of the wife, but not for the daughter. All right, let me move on to accessories after the fact. An accessory after the fact, and just like an accessory before the fact, is not to be present, knowing a felony to have been committed. And here is where, in answer to an earlier question, I can marry both misprisoner felony and being an accessory after the fact. To have been committed by another, did receive, comfort, harbor, assist, and maintain the principle. So in Jamaica, what is the usual way? So people commit crime. Police have you on TV as a person. Well, let me go back to the good old days, when the police never used to use person of interest as if they were looking for you as a suspect. The police looking for you and wanted poster and everything. And you go and you hide out at some relative or friend. Sometimes you see the police charge harboring fugitive for this. And you go and you feeding the person and you're buying him credit and all of these things and you're helping him avoid arrest by the police. Or, in a recent gang case that we are doing, matter of the Queen and Euchence Wilson, where Mr. Wilson, it is alleged, had engaged the police in a shootout and he was shot in his leg, and Mr. Wilson's girlfriend took him all the way from St. Catherine to a doctor in Mandeville for him to be treated and managed to avoid whatever dragnet that the police had. So she was an accessory. She was charged as being an accessory after the fact, but that's a statutory accessory case. So you see this happen a lot. A lot of it usually is people harboring fugitives knowing that they are wanted by the police. So I know at present there is actually a case in the Hanover Circuit, the Queen and Yasser James, big criminal in Hanover. We have about 4 murder cases with him in Hanover. But on one of these, he escaped to St. Catherine. Spanish Town again, you know, I really don't know why. Anybody in here from Spanish Town? I'm going to be very respectful because I don't know who your connections are. So he goes and he hides out in Spanish Town. This is despite the fact that the police have been blanketing the airwaves that they're looking for Yasser James, Yasser James, Yasser James. And eventually he's found in St. Catherine. So that person has actually been charged for being an accessory after the fact. And I think we transferred the matter from St. Catherine to join it in Hanover with the murder. So, no relationship of person can excuse the willful receipt. So, children are not excused, parents are not excused, or spouses are not excused. All can be charged for being an accessory after the fact. You would not be an accessory after the fact if you were a doctor and you professionally attended a sick, wounded felon, because you know your Hippocratic oath says, do no harm, you are to go and help all manner of persons, and so on. Number 2, advise your friends to write witnesses not to appear against so-and-so at his trial. Now, while you may not be an accessory after a fact here, you could still be charged for attempting to pervert the course of justice here. So don't try number 2. Agrees for money not to give evidence against the felon. You would not be an accessory after the fact here, but you could be charged under the old common law offense of compounding a felony by taking money not to give evidence. Knows of the felony but does not disclose it. Again, you would not be charged an accessory after the fact, but you could be charged for misprision of felony. So you will see that for every one of these exceptions, there's a counter exception. So what I'm going to advise you here, do not use this as a blueprint to get out of committing crimes. So now, there are also cases where you have victims as parties. Now, before certain legislative amendments took place, there were certain kinds of offenses that the victim could be seen as a party. So like in the bad old days of carnal abuse, where it was only men who could be charged, you had many cases where the girl, although under 16, was quite up to the sex. She was hot to trot, you know. And what the law said was that these laws were also passed to protect the victim from themselves. So you have those kinds of cases. So in some of the parts of the Caribbean where you still have these older laws still in existence, that would be such a case. Let me move and go through this area quickly. Now, you will all remember that for some time, one Mr. Mark Myrie was a guest of Mr. Obama and then later Mr. Trump, finally being released, and I had a big welcome home concert. And what was his defense at the time when he was arrested and charged? Entrapment. You all know who I'm talking about when I say Mark Myrie. Very well. Now, although the United States is also a common law jurisdiction, like many of the Caribbean countries which we reside in, there are some differences. So, in the United States, entrapment is a defense. It's a complete defense. You are entitled to be acquitted if you have been found to be entrapped by the police or law enforcement. In Jamaica and the Caribbean, entrapment is not a defense. So if it had happened out here, a court could not take account of Buju's defense. So that is one. That's a difference between the United States and us. The second thing is an agent provocateur, and I hope I pronounce it correctly because it's a French term, is not regarded as an accomplice. Who is an agent provocateur? The standard agent provocateur is an undercover police. Your standard agent provocateur is an undercover police, a police doing an undercover operation. And the law regards that person as not an accomplice. Although I don't think in Buju's case it was an undercover police. So if you look at some of these cases here in relation to agent provocateur, the Queen against Thompson is an Obia case, 1924 from East Kingston. The police officer actually used his wife to trap the Obia man. You know, said that his wife was sick, brought the Obia man to her, and man start mix potion and thing and write things on paper and set it afire and all of these things. It was an Obia case. So that police officer who went undercover for the Obia man to cure his wife was not regarded as an accomplice. Andrew and Inez Chambers and Cleveland Arno are ganja cases, again in which the police officers went undercover to pretend to be purchasers of ganja. And they paid for it with marked money. So you know these things work. You go, you pay, you leave, and then the rest of the officers run in. And it is important that they find this marked money. In the Queen against Sang, Sang upholds that principle. And in fact, if you have not started looking at constitutional law, it would be good to get a pre-read of this case. Because the Queen against Sang is the case from the Privy Council that makes the point: unlawfully obtained evidence is still admissible once it is relevant and probative. So the police can break the law and use the fruits of it to convict you once the evidence is relevant. So again, this is a contrast between our cousins up north in the United States. Because in the United States, they have the doctrine of fruits of the poisonous tree. And that once the police have not followed the proper procedures, that evidence can't come in. So let me give an illustration. So if you are in Florida and say, what is your name is? Pardon me? Sonia. And let us say Sonia had murdered Sasha. And let's say Sonia is on her way to get rid of the body, so she has Sasha in her car trunk, the dead body of Sasha in her car trunk. And the police stop Sonia, you know, it being America because she's black. They decide they must search the car. They don't have no warrant. They don't have what is called probable cause. They search the car. Fly car trunk. There is Sasha's dead body in the car trunk. Arrest and charge Sonia for murder. Go to court. Lawyer says, Judge, where was the warrant? Where was the probable cause? Judge says, true, you didn't have anything. Sonia, you're free to go. We apologize that the police wasted your time. Let us say now the same thing happens out here. Sonia is driving with Sasha's dead body. And the police stop you in a spot check. And I think we use one of the state of emergency ones, a random spot check, where generally, although they don't have no reasonable excuse or a reasonable suspicion, they're still searching your car. So they pop Sonia's trunk and they find this dead body of Sasha. So, you know, arrest Sonia, haul her, put her at Central Village lockup for women. and then she comes to court. Now let us say Sonny has a lawyer who tries to argue the same thing. Says, Judge, it was an unlawful spot check. The police had no basis to search her car trunk. And the judge will say, yes, that may be true, but you know, counsel, what was that dead body doing in that car trunk? So there it goes. So it's better to commit crimes in some countries than out here. But Sang is authority for that principle. So Sang is authority for that principle, and Sang is an agent provocateur case. So Sang is really saying that the fact that the police acted illegally and may have broken laws to arrest and charge you, that is no reason to exclude the evidence from the court's consideration as to your guilt or innocence. So, over the years, there has been some misgiving about the evidence of agents provocateurs. So in the same Obia case, Rex and Thompson, Mr. Justice DeFreitas said that a suspected person should not be incited or encouraged. In Brannan and Peake, 1948, 1 King's Bench at 68, Lord Goddard was against using police as agents provocateurs, totally. So some rules have been developed in relation to these cases. One, the police are not to force, persuade, encourage, or coerce relevant suspects into committing a crime. Meaning, if they're acting undercover, say that they're buying cocaine or so on, they're not to force you to do it. They're not to use the hard sell in relation to it. Neither are they to participate in procure or counsel the commission of any criminal offense, because you've had some cases, and I'm thinking about one in Australia, in which the police tracking a heroin ring actually facilitated the importation of heroin from Malaysia into Australia. So the High Court of Australia said, no, you've gone too far. So you can't encourage or the commission of any offense. Let me move on. Let me just make reference to this case, the Queen and Craigie. Craig is a Jamaican case. And again, it's a case in which it was a joint operation between the police and the Drug Enforcement Agency. And again, it was a case where the drug enforcement agents were acting undercover. Craig was actually a policeman. He was actually involved in this illegal drug case. And it's a case out of Montego Bay, the lawless city, the wild, wild west, you know. So, again, they were arguing as to whether or not these DEA agents were accomplices. And again, they were arguing about the ethics of the method. But the Jamaican court practically and realistically held that investigation and detection in some criminal enterprises would be impossible without the use of an agent provocateur. So there are some crimes you can't investigate unless you have an agent provocateur in. So there are some gang cases in which police go undercover. That's perhaps sometimes the only way. If you can't get an informant out of the gang, this is the only way you can get evidence out of the gang. Let me move on. So we come now to the exciting and sexy area of joint enterprise. And in any criminal case, when you become lawyers, either in Jamaica or the Caribbean, where you are dealing with two or more, you're going to have to confront this theory of law. Common design or joint enterprise. So a lot of the cases, nice juicy cases, deal with this area. And it is an area, if I may say, and again, this is my opinion, and not the opinion of the DPP or Ms. Llewellyn, it is an area that has been occasioned by much confusion. The common law courts still have not got it right. And after 30 years of operating on one particular principle, in 2017, in Jogi and Radek, the Privy Council / United Kingdom Supreme Court said, well, you know, these last 30 years, the law took a wrong turn. So for the last 30 years, we've all been practicing bad law. So it's not an easy area for courts to grapple with. So if you look at Anderson and Morris, 1966 to All England Reports at page 644, this case gives you the classic definition of what a joint enterprise is. So you should read it, if at least only to get the definition. Queen and Anderson and Morris, 1966 to All England Report, page 644. I have just thrown this in. This is perhaps a more concise definition from the South African courts, where they call it common purpose. Now, it is important. The liability extends to and includes unusual occurrences from the execution of the joint enterprise. So let me give you an example. I'm going to use the example of Sutcliffe and Barrett. Now, Sutcliffe and Barrett were part of a gang that had been robbing gas stations. And in fact, the last gas station they had run was at Fontabelle in St. Mary. Any nice, innocent St. Mary people here today? All right, so you put up your hands. If I come back here for sexual offenses, you won't like what I say about St. Mary here. But anyway, they had been robbing gas stations in St. Mary. And the alarm had gone out over the police radio. So they were held. The car was stopped at Runaway Bay in St. Anne, the Garden Parish, a wonderful parish. My mother is from this parish. So it was stopped at Runaway Bay in St. Anne. And now, this was the 70s. And although crime was just really beginning to take off in the 70s, in country parts, police were not aware then as they are now. So they stopped the car. Everybody comes out. Police didn't do any search of the men. So one of the men backs a gun and shoots and kills one of the police officers there. Police returned fire, men scattered. I think the man who actually killed the officer shot and killed there. I think it was 5 of them. And Sutcliffe and Barrett were the only ones to have been taken back alive to go and face trial. Well, you know, it's an unwritten rule. If you kill police, don't expect to be taken in alive. I say this, my own personal opinion, not saying it's a truth. So Sutcliffe and Barrett are apprehended. What does Sutcliffe and Barrett say? And I use Sutcliffe and Barrett because it's an interesting case. Bearing in mind how Jogi was decided, the issue is now whether or not Sutcliffe and Barrett can be said to be correctly decided. Sutcliffe and Barrett's defense was that, look, I only went along for the robbery. Yes, I knew that my compatriots were armed with a firearm, but I was shocked when he pulled the gun and killed the police officer. So what Sutcliffe and Barrett are saying is, yes, I can charge me for illegal possession of firearm. Yes, you can charge me for the robbery of the gas stations. But no, I am innocent of the murder of this police officer. I had no idea that whoever is dead now, was going to shoot and kill the officer. Court of Appeal didn't bite. Court of Appeal said, the fact is, you went on this endeavor with the gun. The gun couldn't have been there for sure. The gun, you must have intended to use the gun to enforce your will. So what the Court of Appeal of Jamaica was saying, you are responsible for this unusual occurrence. And again, I say, this was the days when we were hanging people, so Sutcliffe and Barrett have goodly been hanged and executed already. But looking at the facts of that case, and looking at how Jogi has been decided, the issue is now whether Sutcliffe and Barrett can be said to be properly decided, although this is a case that preceded Wing-Siu, which we're going to come to. So in ABCD and the Queen, this case outlines 3 common situations in which common design or joint enterprise arises. So let me move on to some principles. Evidence must be led against each co-accused separately. So you know when you're doing a criminal trial of more than one person, the tribunal of fact, whether it is the judge alone or the jury, must consider the evidence against each accused person separately. Can't join up everybody and bungle up everybody and then convict you on just that alone. Joint enterprise cases, you must prove the actus reus. Number 3, and that is important, you must show what the scope of the common design is. Meaning, what exactly was the agreement? Was the agreement to rob, and then if anybody decides to fight back, you're going to kill them? So you have to know what the scope of the common design was. Where joint enterprise is proved, then all the participants are liable for the acts, including unusual occurrences. The intent to join the enterprise must be formed before the crime is committed, even if only a moment before. And I took that from a Cayman Islands case, Banks and the Queen. Now, let me come back to this, because in Jamaica at present, with the passage of the Criminal Justice Suppression of Criminal Organizations Act, or known colloquially as the Anti-Gang Act, you will recall I started out by saying, where 3 or more participate in the commission of an offense, you can be charged with participating in a criminal organization. And the legislation has been drawn so broadly that it doesn't matter that you formed this organization just a moment before you committed the crime. That 3 on the spur of the moment said, let me gang and beat him, or let me gang and rob her. So it doesn't matter. So basically, it's a principle of common design joint enterprise which has been enacted into a criminal offense. So we come now to what caused the problem, and that is the decision in Wing-Siu. So you can't understand common design unless you read the Privy Council's decision in Wing-Siu, because this is the case that they said took a wrong turn in 1985. So Wing-Siu is reported at 1985 appeal cases at page 168. So before you read Jogi, you must read Wing-Siu, because you will not understand Jogi unless you have read Wing-Siu before. What Wing-Siu said was that all those that take part in an unlawful joint enterprise would have the necessary intent to be guilty of murder or grievous bodily harm if they had foreseen that the infliction of serious bodily harm would be a possible incident of the joint enterprise. So this is where the problem started, that part about foreseeability. As long as you contemplated that this was a possible result, even if you did not intend it, according to Wing-Siu, you would be liable. So let us come back to Sutcliffe and Barrett again. So the fact is, Sutcliffe and Barrett knew that their compatriot had a gun, knew that the gun had been used in robberies, and had the foresight that it is quite possible that the gun would have to be used if anybody resisted. So what Wing-Siu did was to equate foresight with mens rea. Once you had the foresight, you had the mens rea. So this is where they said the law took the wrong turn. So if you read certain journal articles and so on, you will see the rule in Wing-Siu described as parasitic accessorial liability. I say this here because if you read Jogi, you're going to see the term used throughout the judgment. Parasitic accessorial liability. So, let us come now to what were the great issues with Chan Wing-Siu. So the first problem with Chan Wing-Siu was intentionality. The mistaken attribution of criminal liability for contributors who do not intend to further the criminal purpose of the enterprise. Come back to Sutcliffe and Barrett. Sutcliffe and Barrett said, I was only a part of the robberies. And so they were taking themselves away from the murder of the police officer, saying, I did not have the mens rea to murder the police officer. So that was the first issue with Chan Wing-Siu, intentionality. So what it was saying is that the common design cases were too broad and people were being convicted too easily just because of intent, just because they were caught in situations which they did not intend. The next one was foreseeability. The fact is that foreseeability was equated with mens rea. So as long as it was foreseen but not intended, you had the mens rea, was what Chan Wing-Siu decision said. And then the third part was of equal culpability. Should the person who did not intend to kill be sentenced in the same way as the person who killed? Should he be found guilty of the murder even though he did not have the mens rea to commit the murder? So those were the three main issues with Chan Wing-Siu. Let me go back and do them again. Intentionality, foreseeability, and equal culpability. So then, now we come to the Queen and Jogi and the Queen and Radek, reported at 2016 87 West Indian Reports at page 439. And I'll give you a tip. You should always look at the reported decision of a case. Not only because the head note sometimes summarizes rather than having to read hundreds of pages of judgment. But you should always read the reported decision. Just as how if you go to court, you should always cite the reported decision and not the unreported ones if there's a reported one available. So look at the West Indian Report case. So Jogi, and I'm going to start with number 2, was whether the accessory intended to encourage or assist D1 to commit the crime. So again, Jogi comes back to the whole issue of mens rea in the joint enterprise. And they set out these 8 principles. And they also look at the principles to be applied if it's more than one person involved, what they call multi-handed attacks. So after Jogi was decided, in the Caribbean, there were some cases then which began applying Jogi. So let's look at the first one. In Jamaica, Jogi was applied in the matter of Joel Brown and Lance Matthias against the Queen. This is on the Jamaican Court of Appeal website, 2018 JMCA Crim 5. Joel Brown and Lance Matthias. Mr. Leng, I don't know if you remember Mr. Matthias, but when I was a clerk, he had a string of cases out there in Spanish Town, and I left Spanish Town from 2004. But anyway, he had been charged for this, burglary and murder. And in fact, I should actually say something about Lance Matthias and Joel Brown. This is the case we used to respond to the Jogi submissions in the Adidja Palmer appeal, to show why the submissions they were making on Jogi were not relevant to the case at bar. So it's a nice case to read. Justice MacDonald Bishop goes through Jogi. And in the end, she says that Jogi does not apply, and says that all of them, rather Brown and Lance Matthias, were joint principals in this case. Then we come to Guyana. Now, the application of Jogi here in Guyana was different. The issue here in the case from Guyana was whether Jogi applied or Wing-Siu was the controlling authority. So I want you to look at James Hiles and Mark Williams, the DPP. This one is on the CCJ website, 2018 CCJ 12. Because it's really a case of stare decisis. Which authority applies? Is it the Privy Council decision of Wing-Siu, or is it the decision in Jogi? Because at the CCJ, well, let me go back to the trial. So at the trial in DPP and Williams, the judge used Wing-Siu in summing up to the jury, and they were convicted. At the Court of Appeal, although this was a case that was decided 3 years before Jogi, the Court of Appeal in Guyana criticized the trial judge, saying, you know, wrong law, wrong doctrine. And what the Guyanese have, which is what I wish we had, is that their prosecution has a right of appeal. In this way, Jamaica is still backward. So the DPP in Guyana looks and says, but no, this can't go so. They can't let go these man them. So she appeals to the CCJ. And what does the CCJ hold? What did the CCJ hold? The CCJ held that Wing-Siu remains binding on Guyana until set aside by the CCJ. So you know that Guyanese appeals go to the CCJ. But since the issue of Jogi really wasn't before the CCJ, they did not make a decision on it, except to say, you still have to do Wing-Siu until somebody brings an appeal to us. So that was a case of Jogi and Wing-Siu. So come now to Trinidad and Tobago. In Trinidad and Tobago, the case of Edwards and the state, a decision of the Court of Appeal of Trinidad and Tobago. And it's reported in 2016, 4 law reports of the Commonwealth at page 360. If you don't find it there, you should be able to find it on the Judiciary of Trinidad and Tobago website. So this is a case in which Madam Justice Weeks, as she then was before she became President of the Republic, wrote the decision. And again, she looked at the whole thing of Jogi, and she looked at the whole thing of murder and mens rea and so on. But that's not the only case. Now I want to come to 2 sets of cases which I think are interesting. Cases out of the Bahamas and another case out of St. Vincent. Are there any Bahamians here today? None? Now the case from the Bahamas is interesting because you have this penal code in the Bahamas, section 12.3. And you have this decision out of the Bahamas from 1973, full 12 years before Wing-Siu. And so this provision had been considered in a Privy Council decision, Philip Farquharson and the Queen, 1973 AC 786, in which I look at the whole thing of joint enterprise liability in the Bahamas in relation to the penal code. Since there are no Bahamians here, I'm not going to stress too much on this case, except to say, in Rodney Johnson, a case decided by the Court of Appeal of the Bahamas in 2017, President Allen, President of the Court of Appeal, held, and you could see, I don't know if I was wrong, but you could see that she was kind of throwing shade on the rest of the Caribbean, when she was saying, well, you know, we know that Jogi has affected the law in many other parts of the Caribbean. But based on our penal code and the decision on Philip Farquharson, the decision in Wing-Siu was never a part of the law of the Bahamas. So you have that exception. So notwithstanding that we're all Commonwealth countries, the penal code in the Bahamas had affected the reception of Wing-Siu in that jurisdiction. So the Bahamians were actually following now what Jogi prescribed, they had been doing it from long before. Then we come to St. Vincent and the Grenadines. And we come to their criminal code, section 21. Now, the interesting thing about when you look on section 21 of the criminal code is the primacy it gives to foreseeability. It speaks about foreseeability in their criminal code. So when we come to Anne J. Charles and the Queen, which I had mentioned before, Mr. Justice Webster says, well, you know, the whole issue of joint enterprise is governed by the criminal code and not the common law. And really, if you look at Anne J. Charles and you look at the criminal code, it is my submission that Wing-Siu still applies in St. Vincent and the Grenadines, whereas it may not apply anywhere else in the Caribbean. So they are still using foreseeability, and they are still using the principles in Wing-Siu because they have not received Jogi as part of the common law, but because they have a statutory provision which governs it. I want to bring a case to your attention which I think you should read. It's not a Caribbean case, but I found it very interesting and I wish to commend it to you. Because this Jogi has not been received very well in other parts of the Commonwealth. It has not been received in Australia. It has not been received in New Zealand. But the case which I wish to commend to you to read, why do I commend this case to you? It's a case from the Court of Final Appeal of Hong Kong. And this court decided they were not going to apply Jogi, and they went through Jogi point by point, looking at the cases Jogi looked at to come to their decision in the opposite direction. So their case is, let me give it to you, HKSAR v. Chan, C-H-A-N, one word, Kam, K-A-M, another word, and Shing, S-H-I-N-G. And it can be found on the Hong Kong website. It's at 2016 HK CFA 87. HK CFA 87 in the year 2016. So what does the Hong Kong court say? They gave 3 points, and I'm going to go through them quickly. 1, it did not accept that Wing-Siu overextended the accomplice's liability. 2, they also submitted, also ruled, that the way how Jogi has been decided leaves gaps in the law of criminal complicity, depriving it of valuable principles for dealing with situations. And thirdly, the Hong Kong court says that the concept of conditional intent introduced in Jogi caused conceptual and practical difficulties. So the Hong Kong court says, yeah, Jogi is fine for you, but we are sticking with Wing-Siu. That's poetry, and I didn't even know it. So let us move on. I'll try to finish up as quickly as possible. So you have these common design cases, you have this whole thing of intent foreseeability, but can you get out of a common design case easily? Now, let me warn you all here. It is quite easy to join a criminal enterprise. It is the hardest thing to get out of it. And what these cases in relation to withdrawal from the common design say is that you really need to show an unequivocal act that you are not a part of the joint enterprise. So if you look at one of the classic cases in this area, Becker and Cooper, a mere change of mental intention and a quitting of the scene just immediately will not release you from being part of the joint enterprise. They go on to say, there must be practicable and timely communication of the intention to abandon the common purpose. And what is timely communication must be determined by the circumstances of each case. So you will have cases in which people have planned out the thing, and on the day in question, you don't turn up to do your part. What this law is saying is that is not enough to say that you are not a part of the common design. One, if you didn't communicate to your fellows, and two, really and truly what I think the judges are saying is timely communication really means you need to inform on these people and stop the enterprise from going forward, really to tell the police, and that's the only way you're going to show that you are not a part of the common design. That is just my view. So these are some of the cases you should look at, especially that first one on the list, the Queen and White House. 1941, One Dominion Law Reports at page 683. Why do I say the Queen and White House? Because this gives the classic legal principle on withdrawal from the common design. So although you may look at later cases, you will see them coming back to reference White House. So you should read White House. Some other interesting cases, for example, Alton Heath against the Queen. Now, Alton Heath was a particularly gruesome case, and it took place somewhere off Marcus Garvey Drive. So these girls allegedly disrespected the brother of the area leader. So what does he do with these two girls? So he has them kidnapped. He has them brought to Tinson Pen Aerodrome. He has them raped. And then he shoots them. And then there's this big open culvert apparently there where you throw the bodies in and they get washed out to sea. Well, this girl, thank God for being a board-head girl, because she survived the shooting. She survived the shooting, and in fact, in her testimony, she speaks about hearing the other body slide past her in the culvert. It is true, it was probably not her time. And so she lived to come and testify against these persons. Now, it is interesting the defense that was being run, because while the men admitted, yes, I was at Tinson Pen, all of these men managed to find that at the point of the shooting, at the point of the rape and the shooting and the disposal of the bodies, well, I was over that part of the aerodrome when that happened. And I was over that part of the aerodrome when it happened. And I was over this part. So everybody was doing a Mr. Vegas in the days when he was sane and before he went quite mad. So, so everybody was taking away themselves. What does the Jamaican Court of Appeal say? No, that's not a proper taking away of yourself. And so they applied classic doctrine on withdrawal of the common design. Wayne Spence is the murder of a policewoman on a passenger bus on ferry. When these men came and held up the bus, and one of them recognized the policewoman, and they raped her and killed her. And Wayne Spence is saying, well, I told them not to shoot her. Trevor Bennett is the murder of a judge. And Trevor Bennett is saying, look, we got here to block the man's house. I thought it was a robbery. I didn't know they were going to kill the judge. Michael Maharaj and the state of Trinidad and Tobago. Now, this is a case where some 11 or 12 persons went on trial for a kidnapping and a murder. You know that if you go to Trinidad and Tobago, try not to get kidnapped over there, because it's a sign that you may not come back alive. And they were doing beheadings long before it became fashionable in Jamaica. So Maharaj is one such case. And what one of the defendants in Maharaj was saying, yes, I was a part of the plan, but on the day of the plan, I went elsewhere. Mr. Justice Sharma, who was the Chief Justice at the time, said that was not an effective withdrawal from the common design. And I'm wrapping up, but I could not leave the area of common design without mentioning the case of the Queen and Gunango. 2012, one appeal cases at page 827, because I mention it as an unusual case, because Gunango is a transferred malice case in which the Supreme Court of the United Kingdom applied joint enterprise theory. Now, it's a case when you read it, the impression you get is that, boy, the judges are really trying hard to apply joint enterprise to this case. What is Gunango about? Gunango, now, we always tend to think that the United Kingdom is a much safer country than Jamaica or even other countries in the Caribbean. But Gunango dealt with a shootout on the streets of London between two gunmen. I saw like Gunango actually was of African descent, though. So these two gunmen meet up on each other. They are of different gangs, and they begin shooting at each other on the crowded street. So this lady, as far as we know, she's on her way from work to go to her yard, minding her own business. And she's shot and killed in the crossfire. Now, when the forensic experts did their thing, a matching trajectory and so on, the bullet that killed this lady did not come from the gun fired by Gunango. It was the other man. But they never catch the other man, but then catch Gunango. So Gunango was tried and convicted for murder. So Gunango, and I think rightly says, hold on there. How can this be? It wasn't my gun that killed her. I wasn't the fatal firer. What the United Kingdom Supreme Court held was that there was a joint enterprise between the two gunmen to shoot at each other on the streets in London. And you know what I think reached that court? You know what I think reached that court? You can't have a situation where two people are openly shooting at each other in the street and somebody dead and a man can just walk. Just so. So what I think the Supreme Court of the United Kingdom did was that they weren't being ruled by law at this point. They were being ruled by policy. You cannot have a situation, because what would happen? People may do it again. So poor Gunango was the sacrificial lamb. But it's an interesting case in the application of joint enterprise principles to the area of transferred malice. Because technically, if it's a classic transferred malice case, Gunango should only have been convicted for manslaughter. Well, it's not even him, because it's not even him fired. The other man would have been convicted for manslaughter. The most you could get Gunango for is really shooting with intent. So, this is what they did. There was one dissenting judgment, Lord Carr, and I think you should also read his dissent. And he really is critical of the majority. And that last part in his paragraph, an agreement to shoot and be shot at does not necessarily amount to an intention to assist or encourage the other to shoot. And so, ladies and gentlemen, this brings me to the end of accessorial liability. I hope you find it an interesting area.
So wow. Can I get a wow? Wow. Can I get a wow wow? Okay, so I'm going to invite Amory Brown to come up on stage to present Mr. Taylor with a token of our appreciation, and she will also be given a short or brief vote of thanks to Mr. Taylor. So class, Amory Brown.
Good evening, everyone. Mr. Jeremy Taylor, Senior Deputy Director for Public Prosecutions. I, on behalf of the first year law students and the Faculty of Law of the University of West Indies, Mona and Cave Hill, would like to extend my utmost gratitude to you for taking time out of your very busy schedule to make this presentation to us on accomplice liability. We really benefited from what you presented in terms of what the facts of the case in the adhesion problem case and the liability of Mr. Campbell, as well as the categories of accomplice, how the Jogi case and the Wing-Siu case was applied in various jurisdictions, among other things. It was a really entertaining lecture, and once again, we thank you for being here. We truly appreciate it.
Thank you again for the invitation. I think you're the one class that has not walked out.
Have a good evening, everyone, and thank you so much.